Thank you, Chairman Keeble and members of the committee. I appreciate this opportunity. I am a Uniform Law Commissioner appointed through the process in Rhode Island. You have seen me here before you on a number of other acts that have been promulgated by the Uniform Law Commission. This one has a long history with the Uniform Law Commission. It was the Uniform Law Commission that first promulgated the 1973 Act. Rhode Island adopted that, but did not adopt the revisions that were proposed and promulgated by the ULC in 2000 and 2002. And frankly, if this particular act is adopted, no harm done, because the 2017 Act, which is before you, cures a number of the defects in the 2002. I submitted a package to you this evening. It includes the actual act, the Uniform Parentage Act, as it was promulgated by the Uniform Law Commission just last year at their annual meeting. And I gave that to you only because I think if you have any particular questions about it, this is an annotated copy of the Act, and you can look up some of the background materials that are included to explain how the Uniform Law Commission arrived at the conclusion that it did. But in any event, some of the other handouts that I had for you, basically in summary, are one-pagers explaining the Act. And the Uniform Law Commission enthusiastically supports this Act and hopes that it will be enacted in Rhode Island. And as often the case, the Uniform Law Commission isn't trying to do anything to change society, but reacting to what is today, and to do so with a response which we believe is rational and well-advised for the entire country. A couple of points that I'd like to make, and I'd like to commend all the previous speakers, especially Shaun Feeney, who did a magnificent job of going through the Act and explaining the legal detail. But just a few other things I'll mention, and that is, there was this Supreme Court case you may be familiar with. It's the United States Supreme Court decision in Obergefell versus Hodges in 2015. And then there was a follow-up case that was also in the same area that was Pavan versus Smith, again, a United States Supreme Court case. The Obergefell case was the Supreme Court case that held that laws barring marriage between two people of the same sex are unconstitutional. And then the Pavan case, which followed it shortly thereafter, in fact, last year, the court reaffirmed that that conclusion applies to rules regarding children born to same-sex spouses. After these decisions, state parentage laws that treat same-sex couples differently than different-sex couples are likely unconstitutional. By adopting this current Uniform Parentage Act of 2017, states can avoid litigation over these issues and uphold constitutional protections. Another point is that this particular act complies with federal laws tied to subsidies and financial incentives that go directly to states. States' receipt of federal subsidies for the Child Support Enforcement Program is contingent on compliance with Title IV-D requirements, and the Federal Office of Child Support and Enforcement has worked with the Uniform Law Commission in drafting this Uniform Partnership Act last year to ensure that the updates all comply with those federal requirements. So with the addition of these new provisions that are in this act before you, that preclude the establishment of a parent-child relationship also by the perpetrator of a sexual assault that might have resulted in the conception of the child. So it deals with that issue as well, to prevent that perpetrator from claiming the rights as a parent. There are also a number of other provisions that have already been explained to you that I'll just briefly mention. The surrogacy provisions of the UPA, reflecting developments in modern science. And it also addresses the rights of children born through assisted reproductive technology to access medical and identifying information regarding any donor providers. And the reason why this is important is because there may be need to know genetic history sometimes, and so this law would allow a child born through assisted reproductive technology to go back and find out as much as possible, but without necessarily disclosing the identity of the provider. And so there's a protection of that right, but still an effort to make this information available to one who might be in need of that medical history information. So, I mean, you've had a great testimony here this evening, and I'll be happy to answer any more questions, but I think it's all been pretty well covered.